continuing on the procurement things, we see a very recent development now. The introduction of a new national identity card and a license or card system. I think what we are beginning to hear is that the card printing is to be allocated to some military organization again. Now this is a matter of concern for us. Not because of the cost saving or any other interest, but has the military organizations got a right to get involved in business affairs? Essentially, the printing of a card or supplying of some material to the central government becomes a deal or a transaction between the government and that agency and that organization. So, is it regular for another government organ to get involved in that process? Doesn't it violate the procurement principle? I think this is a matter of concern for us, because the Central Bank of Sri Lanka, for example, is not allowed to do business. But it is in charge of the economy. It has to maintain balance in the currencies, in the economy of the country, and all other economically related affairs and matters. But Central Bank cannot get involved in any business work. They can promote, they can control, they can administrate, but they can't get involved. Here is a case where a military organization, if the army or somebody is getting involved in the printing of cards and printing of licenses, identity cards and so on, which is essentially a function to be done by an agency under procurement rules, because it has definitely a cost, an expenditure, which has to be sort of shared between the government and the party who is doing it. So therefore, in such instances, it looks a bit suspicious. Why? The tender procedures and the normal procurement process should be deviated to entrust this type of jobs to military or army or some other government organization itself. Now, besides the principle involved in procurement process, there is another factor. We are virtually granting a sort of access for public information, of personal information of the members of the public to the army. Why should we do that? If the army of the country requires some information for some security purpose, well, it is acceptable. They can retrieve such information or obtain such information from the officials or bodies concerned or handling those matters. The Registrar General of the country is entrusted under the law of the country to maintain records about the citizens of the country. When such information is freely made available to the army, under whatever circumstances, it looks a bit of a excessive thing, bit of information about the civilian society falling into the hands of the military, which is not expected or valued under a democratic government. Therefore, these are some concerns that the public have entertained. They should be addressed, because we have an efficient person as the president, who only has, according to our knowledge and experience in the field of army and the armed forces, such things can happen. But we have to point out that this is not regular. It can lead to lots of other things. It's the individual freedom. We don't want to share our personal information other than with the respective relevant government authority. Nobody would like to do that. Why? Unless we are going towards a dictatorship. Such information need not be in the hands of the services. The services are called upon to exercise certain regulatory requirements under the civil administration. not an administration by themselves. Therefore, over and above the procurement part, the financial involvements and the principles involved behind those, we are also worried about this aspect of the matter, that the information dealing with the public, personal information, which should, which forms a part of in the application to a national identity card, in the application to a license, driving license or whatever, you furnish a lot of information in that, which need not fall into the hands of the military unless otherwise it is required for a certain purpose, under special circumstances, not generally. Generally, so such information should lie on or should be kept with the authorities enacted, authorized to do so. Obviously it is the Registrar General or the Registrar or somebody of that in that capacity. Therefore, this is a matter that has to be looked into. There is another concern now. That we heard announcements being made over the radio and then in the public media that there is government is going to take a step, some new step for modifying the birth certificates. Modifying the birth certificates. I don't know, some need as a reason. It looks like in the eyes of somebody in the administration that certain changes are immediately required. We don't know for what purpose and with what ulterior motive. But we are aware that the registration of a birth of a person in this country is governed by a certain act which is enacted by Parliament. Now, today, under the existing laws, there is what is called the Births and Deaths Registration Act, which is a very old regulation going back to 1950s, and then which is in existence. This act provides specifically it gives certain sections which stipulates the nature of the certificate to be issued as a birth certificate, the type of information that should be contained in a certificate issued by the Registrar General's Department to a citizen of the country. And in compiling that information as a record of the state, the law provides for certain filling in of certain forms, issuing of some primary certificates, the final certificates, the manner in which such certificates are furnished are all stipulated in the act. Now, if somebody thinks that, by virtue of some power, unseen authority, if somebody can direct, okay, you drop this side topic can include this, no need to have a citizen's name, no need to have the names of parents, no need to state whether the parents were married. These are very serious things. These are matters for the legal profession to look into. Nobody speaks in public today. That's the most unfortunate thing. The lawyers are virtually silent. They are in the fray, in the election fight, game. They are contesting from this side, that side, but they are forgetting what is happening in the legal field. Some odd things are happening. We know a series of laws are there related to these births and deaths. A birth certificate provides the information about the person, about a person, his parents, parental status. The fact that a person is the child of a married couple is different for him to become a child of a unmarried couple, because the heredity, the continuation of the ownership of the properties held by the parents are passed on, are dealt with according to the parental heritage, according to the law. The Civil Procedure Code, the Evidence Ordinance, and the Partition Law, the Notarial Law, all referred to the ownership of properties through generations by referring to whose son and whose parent the subject matter is falling within. So if that is done away with, we are going to have a lot of complications in this field. I mean, as a layman, that is how I can see it. These are matters where the lawyers of the country should address these issues in public interest. If lawyers are there only to appear on the payment of a fee in some respect to in the courts, I mean, that is not done for it's not sufficient for that profession. That profession is a very valuable profession. The society requires their guidance. The society requires their opinions. Society requires their intervention. If they only are there to appear for somebody on the payment of a fee, and that is their only function, it is wrong. It's very bad. Therefore, we as members of the public, we want to state that there is a very big concern about this birth certificate thing. Whether the column that is dealing with the citizenship should be removed, why it should be done, for whose benefit it is done. All these things become very relevant because various things are happening now. Now there was a question about the citizenship of the candidates who are coming forward as for various election purposes. Some people are deprived of contesting the election despite their desire to do so, getting involved in the background, controlling the whole affairs by remaining in the background, who have been kept out only because of these impediments like the citizenship. So we don't know whether such things are indirect moves on the sly to accommodate such people. So whatever it is, citizenship is a thing that every country values today. I mean, they have a regard. If you become a dual citizen, you mention that. You are a citizen of this country, by virtue of which you are entitled to these things. You are at the same time a citizen of another country, by virtue of which you are entitled to certain other things. Sometimes the citizenship of one country precludes a person from becoming a citizen of another country. For example, the Arjuna Mahendran's case. He was a citizen of Sri Lanka. He changed his citizenship to Singapore. Now he is a Singaporean citizenship. He changes his name and he remains. Sri Lanka cannot exercise the legal authority on him. He is not a citizen. Despite which he was brought in and put to the highest place by the then Prime Minister Ranil Wickremesinghe to handle the affairs of the central bank. So when such things are happening in the political scenario, disregarding the damage that can be caused to the country in general, we are concerned about these things, whether such changes should be effected in this manner. Particularly, we are concerned with the fact that whether anybody has authority to do so, to change certain provisions in acts without going before the parliament. Who has that authority? I think it is only the legislature that has the authority. To the best of our knowledge, the specimen form in which the birth certificate is issued is given as a draft in the appendices of the Act. And if somebody tries to deviate or drop certain items in that, that means you are dealing with the provisions in the Act. Legislation. Can it be done? Please, the lawyers of this country, the legal profession, look into these matters. These things cannot be even contemplated in this manner. Somebody can say, no, this is at the stage of contemplation. What is the contemplation? Such matters should be dealt only with by a parliament, the legislature, which has the power to, authority to change, if necessary, and with justification. It becomes a transparent, open, public affair in which the public can contribute and go to courts if that is wrong. But when it is done in this manner, surreptitiously, secretly, according to the whims and fancies of anybody, I don't know if it is going to be done that way, that is bad. That's not democratic. That is definitely, that leaves room for conjectures, suspicions and doubts about the administration. Therefore, the concerns that are now prevailing in public about the legal matters, about the administration, about the tendency of militarization of the civil administration, all are justified to be addressed properly, to be adequately dealt with by authorities in times of a proper rule. Now this is a interim period. There is no cabinet, we have only an interim cabinet. The interim cabinet is there to carry on till the next permanent cabinet is appointed. We don't want things affecting or lasting many years in the country to be taken, decided upon by an interim cabinet. We stress that and emphasize that and reiterate that position. Please act within the rights that are entitlements and the rights that are available under the law of this country. The rule of law should prevail. People should feel that the rule of law is prevailing. Thank you very much.
සාක්කු පුරවන දේශපාලනය වෙනුවට ජනතාව දිනවන සංවර්ධනයට කැපවන අත්දැකීම් ඇති බැංකුකරුවෙක් මැති සභයට රුසිරිපාල තෙන්නකෝන් අංක 12 ජාතික සංවර්ධන පෙරමුණෙන් කොළඹ දිස්ත්‍රික්කයෙන් මැති සභයට